pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Before we get underway, I have a few preliminary matters. First off, I'd like to welcome everyone to our meeting. Call your attention to the fact that the fire exit is located to your left. In the event of a fire, you will be notified by an announcement. If notified, please move in a calm and orderly fashion to this exit. Do not use the elevator. Use either the front or the back stairs to leave the building. The meetings are recorded by our secretary for the purpose of a record and minutes, so when you come to the microphone, please identify yourself each time that you speak and speak into the microphone so everyone can hear you. We will follow the items on our agenda in the order that they appear. There are extra copies of the agenda on the table at the door if you didn't pick one up on your way in. Once the case has been called, the applicant or their representative will come to the podium, identify themselves, be sworn, state their address, and then present their case. Once the applicant has concluded presenting their case and answering any questions that members of the board may have, then we'll open the case to public input. Anyone wishing to speak to the board regarding the application should come to the podium, identify yourself along with your address, and direct your questions and comments to the board, not to the applicant. We'll take those who wish to speak in favor of the application first, followed by those who wish to speak in opposition. Once everyone who wishes to be heard has been heard, the applicant and/or their representative will have an opportunity to respond to any questions or concerns that were raised during the public input portion of the hearing. Once that's been completed, the case will be closed and we'll move on to the next hearing. During the presentation by the applicant or by anyone who's speaking during the public portion, there is to be no commentary from those who are in attendance, either in support or in opposition of what is being said. If you have a comment concerning the application, come to the podium and let us all in on your comments. Please also be sure and turn your cell phones off, or at least have them on vibrate so that they don't sound during the meeting. Once the applicant has concluded and the case is closed and we've completed all the cases on our agenda, we will then take a recess. Following our recess, we will deliberate on the cases in the order in which the applicants are still present in the room. We will then, during this portion of the hearing, there is no further input from the public. The board will deliberate, discuss the application, and once a resolution is made, we'll make a determination. If you wish to find out the results of our deliberation, you're welcome to stay. You're also free to leave. If you get home in time, you can watch them on Channel 12, or you can call the zoning and the building department at the town hall in the morning. One more matter before we get underway. I'd like to welcome Mr. Thomas, who, as I mentioned to him on the way in, has a unique distinction this evening. He is our newest member of the board, and he is also our senior member of the board, all at the same time. Here, here. All right, the first case on our agenda, please.
ZB 1201-1. Upon the matter of request by Boardwalk Design, Inc., acting as agent for Robert Ross, for an area variance to construct a pergola structure attached to the dwelling with less than required side setback on premises 340 Rock Beach Road in an R1 residential district.
Good evening. My name is Paul Zachman from Boardwalk Design, and I'm the applicant representing the owner, Mr. Ross.
If you could both
I'm sorry, can you repeat your name again?
Yes, Paul Zachman.
Okay, thank you.
Yes.
If you could both raise your right hand, do you swear or affirm that everything you say tonight will be the truth, the whole truth, and nothing but the truth?
I do.
Okay.
We are proposing to construct an attached pergola to the east side of Mr. Ross's residence. He has within a couple of inches, about 8 foot or so of clearance on the side, and he uses that as a driveway access for larger vehicles and things like that in the event he needs to access around the rear of the property or the lakeside. It's a large 3-story facade on the side of that house, and the rest of his home has a lot of nice architectural features, so we're proposing to construct this 3-tiered pergola that will step down with the grade, and we're requesting that the columns for the pergola be out on the property line, situated such as you would see with a fence, and there's no screening or obstruction between the columns. All the construction will be above the top of the columns as we effect sort of like an architectural feature pergola on the house.
Who owns the,
Yeah, I was going to say the same thing.
who owns the property to the, I guess it would be to the east of Mr. Ross's property?
That would be, my name is Robert Ross. I'm the owner of 340 Rock Beach Road. And that would be my neighbor across the street, June McPherson. She owns the adjacent property just to the east of me, and she also owns property across the street from me.
So she owns 336,
I believe that that's the correct number, yes.
but her house is across the street?
Well, right immediately across is like her side yard. Her house is a little bit adjacent, just across and to the east of me, across the street.
Right.
Yeah.
All right.
So when she's in her front window, she's looking right down through her lot to the lake.
Right, okay.
Would you be keeping the bolt under that pergola? That's there now?
I would like to. That was my only concern about the width between the column. Initially, I had hoped to put columns on both sides, but when I looked at it and I measured the width of my car and the width of like my boat trailer, it's really, really tight, and it's my only ingress and egress to the rear of the property. So that was why we were concerned about being able to put those 3 pillars right on the lot line, so we have just enough room, and I'm talking like within inches, to be able to get down there.
Based on the letter that we received from June McPherson, she said that she had no problem with you going up to the lot lines. And I'm just curious, on looking at your map, it looks like you might overhang onto her lot with the columns and some of the overhangs of the top of the structure. Is that true?
If we put the edge of the columns right on the property line, the way it is designed, there is a slight cantilever of the top purlins, so to speak, on the pergola that would overhang several inches based on that design.
Now, the width of the columns, is for so that you can get a car or an automobile or a boat trailer down to the beach.
Yes, and yeah, correct.
Now, does she understand that it's actually going to overhang onto her property? I mean, not that the columns are going to be mounted, but she does not have a house. That's an empty lot, right? That's just beach lot.
Yes.
Does she understand that the overhang or the cantilever is going to go over the top?
I explained it to her just as Paul has explained it to you, that there's a possibility we might be 6 inches, 8 inches, whatever, over slightly.
Okay. I mean, in the event someday she wanted to build her own structure there on the beach, that would, so she knew exactly.
If you look at the survey map also, there's a retaining wall and a driveway sort of footprint that is actually over encroaching on that property even more now. So the pergola will even look like it's inbound of what the apparent property line is. It appears the property line isn't parallel to the house for some reason, but everything that's been developed there over the years is parallel to the house. So it's causing a little bit of a skew there.
Okay, so in other words, the retaining wall, is already on her property.
Parts of it are. I think right out at the very front of the property, it starts out inside of it, as it doesn't run parallel to the property line.
Got it. Okay. Do you think she's aware of the overhang then? Okay.
Any other questions from the board? Is there anyone here to speak in favor of this application? Is there anyone here to speak in opposition to this application? We will close this case and move on to our next case.
Thank you.
Thank you.
Thank you.
ZB 1201-2, upon the matter of request by Sign and Lighting Services, acting as agent for Ridge Goodman LP, for area variances to replace and add signage to 2 freestanding signs exceeding maximum square footage allowable on premises 1381 and 1455 East Ridge Road, Tops Marshalls Plaza, in an M manufacturing district.
Good evening. My name is Nicholas Johnson with Sign and Lighting Services.
You raise your right hand, please. Do you swear or affirm that everything you say tonight will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you.
Basically, what we're looking to do here at this property is take the old dilapidated signs and upgrade them and update them so that they look fresh and revitalized, and try to use everything that we can that's currently existing. Currently, the biggest problem that we have with this sign is that the name of the plaza isn't on there, and I'm sure most people couldn't tell you what the name of the plaza is. So there's a lack of identity for that property, which we've, the landlord has, the owner rather, has mentioned has been a big problem for some of his tenants guiding clients to the property. So they tell them it's the Marshalls Plaza or the Tops Plaza, or they don't know what to call it. So it's very difficult for tenants to guide their customers to the property if they've never been there before. Also, what we have currently, everything is rusting. There's been minor upgrades to the sign over the years, which have since started to degrade and look absolutely horrible, in my opinion. So what we're trying to do is just revitalize it, give it an identity in the neighborhood, and we've added some nice architectural elements to it with the additional column to help also structurally with the additional square footage that we've proposed for the sign. We've added a nice clock to the design to help tie it into the rest of the design, and more so to help that create more of a unique feel in the neighborhood, give it more of a community feel rather than, just another sign out there. I'm sure you've all gotten or received my letter of intent, which I think more clearly describes the reasoning behind why we're looking to propose an additional square footage.
The grass area around the bottom would be exactly as the picture is?
As far as the landscaping,
Yeah, the bottom.
that's, at this point, that is just aesthetic. We haven't developed that at this point. That would be on the landlord to implement later.
So what you're looking at is just the columns? In other words, like more like...
Existing is just the exposed columns,
Right.
but I do know that they have plans to put
landscape.
landscaping around it. They've already told me that they were going to do that. We've also,
Offhand, if there's more than, those 10 signs here, if there's more than 10 tenants that can occupy that plaza?
the 2 additional spaces at the bottom, if you're looking for why those are there, we've noticed over the years that a lot of tenants are becoming smaller and smaller. A lot of big box stores are going away, and you see more and more small businesses because of the internet and things of that nature. It just makes it so that you don't need as much square footage to sell your product. So with that in mind, they're trying to keep the option open if they do have to subdivide a larger parcel, that they have that option to give them a sign. Also, in the meantime, they would use that space as a leasing panel. If there is a vacancy, they can put their panel up there that says, call so-and-so Realtor at this number, things of that nature. But also, on that note, we have designed in here some decorative caps, so to speak, to hide the anchor bolts that are currently exposed in the base plates, because those are pretty ugly as well. And that'll help, when all said and done, it'll help it kind of blend in a little better at the bottom rather than being so rusty.
The reason I brought it up is because without the two bottom sections, you could almost see underneath it when you're driving by. But I didn't know if that was, I see where you're coming from as far as why they want them.
Right. And it is set back in the property far enough so that, there shouldn't be any kind of visual interference with any kind of traffic.
And if this happened to get passed, would an agreement be okay to put in about the landscaping on the bottom of it?
Absolutely. We've already discussed the types of bushes as well. We want to do something a little more low-lying that has good ground cover and color, but nothing real tall or bushy or anything along those lines.
Is just the top half lit, or top part, Rich Goodman Plaza?
No, all of the sign cabinets would be lit. The two, right at this moment when I just drove by tonight, the bottom cabinet is not lit. It probably has a service outage somewhere, bad ballast or something like that. We would take the existing cabinets off the sign, bring those cabinets back to our shop, sand them down, repaint them, put all new acrylic in them, and recycle the old acrylic, put all new lamps in it, all new wiring, all new ballast. So it'll be like a brand new sign, but reusing the old stuff, just to recycle. And anything that we would take out, well, actually, the only thing that we would literally remove from the site and not bring back would be the aluminum cladding that's currently on the side that kind of bumps out and gives that small arch. That would all go away. And we would, of course, repaint the steel, reprime it, repaint it, start by sanding, of course.
And the Marshalls and DeBella's sign's going to be much smaller,
Yes, sir.
but the rest of them you'd basically be reusing?
As far as the cabinet structures, they're going to be the same pretty much. We're going to cut off, I think it's 2 or 3 inches off of the top cabinet so that it will fit inside of the lower poles.
The poles themselves are going
They will stay.
to stay.
We would probably need to put some sort of temporary banner up. I don't believe we would have all the tenants' names on it while we were doing the work. Maybe even a rigid panel, depends on what's requested and what's needed.
So it's going to be the same height, roughly,
Yes, sir. Overall height would be identical.
and basically the same width except for the addition of the clock tower.
That's correct.
Just going to come lower with the signs.
Yes.
Is that third post that's going underneath the clock just going to be there for looks, or do you have to mount a third post?
We are looking to use the third post to distribute some of the additional weight and wind load from the additional square footage of signage onto that third post.
So you are going to mount the third post then?
Yes, it will be permanently anchored.
Good looking sign.
Thank you.
Yeah, I think it's nice to see us investing in our businesses. Not that my wife needs any help finding Marshalls, but it is a nice-looking sign.
Thank you very much.
Any other questions? Is there anyone here to speak in favor of this application? Is there anyone here to speak in opposition to this application?
Thank you for your time.
You're up.
Richard Barone, 154 Allwood Drive. We have a sign problem in this town, gentlemen, and hopefully you can help with it. Over 100 complaints have been filed against local businesses, including Tops, because of signs that are illegal, not in compliance with the agreement they made when they first built the property. And I was involved with some of the signage in this town when I was a councilman. You can argue that it's a code enforcement, but no fines have been levied. Take a look at our town. You'll see signs on the sidewalk. You'll see signs blowing into the road in some cases. You assign 3, 4 signs on a property that never been approved. I've tried to work with Larry Heininger on this, with letters going out. The problem is, the person here tonight is an agent. Where's the owner? In Chicago? Try to get anything done to somebody 3 states away. I'm opposed to increasing any signage. Everyone knows where Tops is. I lived in this town for 45 years. If I say that it's in the Tops Plaza, they know where it is. They know Marshall's is in the Tops Plaza. So that argument, I think, is not very cogent. Here's my suggestion. The problem is you approve a sign or an increase in the signage above the code. The person goes away and does what they want. How about putting a stipulation in your approval that the applicant agrees that that's the only sign they will have on the property, and they will not add any signs unless they get the town approval? Now, you shouldn't have to put that in there. Businessmen should know what the rules are, and a lot of them do. 95% of our businesses in this town follow the rules, and most of them, when a complaint was filed, took care of it. But it's about 13 or 15 businesses, and Tops was one of them. They had a Thanksgiving sign out there for probably at least 2 weeks. Never approved to my knowledge. Town goes down there, talks to somebody. Owner's not here, it's in Chicago. So I think you need to put in the approval, give it to this gentleman, of course, but also send it certified mail to the owner, wherever that owner is. We got a problem. Please, if you don't believe me, take a look on Ridge Road. There's one chiropractor in Seabreeze. His sign blocks the sidewalk. You can't walk on the sidewalk. You got to go into the road. So, a simple statement, stipulation, the owner agrees that this is the only sign they will have on the property, and any other signs, they will get town government approval for any additional signs. By the way, we have a prohibition against sandwich-type signs. We don't even approve them, but they're out there. Now, the town will approve a 2-week special sign for like $100 or something, once a year. They don't even apply for that. They just put the signs out there for weeks. So you have the opportunity, I know you're not the code enforcement guys, but you have an opportunity to put in your approval a stipulation in my mind. Of course, you're going to check with the attorney as to how you would do that if you are willing to do that. But I think that would help this town and keep the signage from getting ridiculous. Thank you.
Thank you. Is there anyone else here who wishes to speak in opposition to this application? And does the applicant's representative have anything further that you'd like to add?
I do. I understand what this gentleman is saying, and I don't know of the examples because I'm not that terribly familiar, but the owner of the property does currently reside in New York City, and they have a representative here in Rochester, Baldwin Realty, Peter Doer, who watches the property, maintains the property, manages the property. He was just brought on, I think, in the past year or so, shortly after the transaction took place of them buying this property. It's not the same owner as it was 10 years ago. These people are taking a very professional approach to try to get the property up to par and keep it that way. Me, myself, I am a sign professional. I'm a very young man still, I think, and I want to be in this town a long time. So I'm going to do everything that I have to do to make sure that my signs comply with my drawings and whatever the town approves. I don't need a bad name. That's what I have to say. Thank you.
Thank you. All right, we'll close that case. Next item on our agenda, I believe, requires a motion to remove the case from the table. Does someone wish to make a motion?
I'll make the motion, Mr. Chairman, that we remove the next case regarding the Brotherhood of St. Joseph from the table.
I'll second it.
All right. Any discussion? All those in favor say aye. Aye. Any opposed? There are no any abstentions? There's no abstentions and no one is absent.
Case ZB 11-12-4, 1280 North Winton Road, Brotherhood of St. Joseph, On the matter of request by Fix Spindleman, Broats and Goldman, acting as agent for the Brotherhood of St. Joseph's to appeal from code interpretations of the town's fire marshal set forth in the notice to vacate dated October 19th, 2011, per Fire Code of New York State, 2010 edition, Section F1074, unlawful structures, and violation of the Zoning Board of Appeals decision dated January 7th, 2008, and Monroe County Supreme Court decision of 2008, Index 208-01890, and more specifically to determine if the current use is in violation of Town Code on premises 1280 North Whitten Road in an R1 residential district.
Good evening, board members. My name is Carl Essler. I'm an attorney with the Office of Fix, Spindleman, Brobitz and Goldman. And with me tonight again is Deacon Keith Leibold of the Brotherhood of St. Joseph.
If you could both raise your right hands. Do you swear or affirm that everything you say tonight will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Obviously, as everyone, I think, understands, this is our applications on behalf of the Brotherhood of St. Joseph regarding orders from the fire marshal, which essentially said that the Brotherhood was continuing to occupy the house in an illegal fashion in violation of the prior court decisions by still running what the board and the court had previously described as a halfway house. And our presentation, if the board will recall, last month explained that the program, we've gotten rid of that program that was of concern, and that now the only persons who reside in the house are formal postulants who have signed formal commitment documents as the beginning membership of the Order of the Brotherhood in writing to begin a path toward a full membership in the Brotherhood. And we showed you all that documentation and just exactly what the position of a postulant means within the Brotherhood. The board had some questions or wanted some additional information. We have provided it. I trust that the board has all seen and reviewed the letters that came from the 5 postulants who currently continue to reside in the House. I think, quite frankly, they speak for themselves in a... well, I'll let the board decide for themselves how to review them, but we were quite satisfied that they answered the question that the board had in that regard. I also submitted a letter. There was a request as to how many postulants had resided in the house during the past 3 years, and I provided the information regarding that. One thing I think I'd like to add at this point, which I think may be helpful, I'll pass this around and give a copy to the clerk. This is a little more specific information on the, and again, I think the board was willing to let us keep last initials only on the names of the individuals, and that's what we did here. But the starting dates and departure dates of these 17 postulants that were there during the course of the past 3 years. And I would simply point out that when you look at this list as a whole, this is not, as you look at the length of the stay, almost all of them were there for at least a year. In many cases, in some cases over 2 years, almost 3 years. These were not individuals. These postulants who have signed that commitment were not individuals who simply were stumbling in off the street, as is, I think, been the concern that some people have, and staying for a few days or a few weeks. These are people who made a commitment, and a fairly sizable commitment as it was. I think it's also fair, I guess, if you look at the next page, the average stay was somewhere around 14 months, and that, of course, is brought down a little bit by the fact of the couple newer people we have on the list. But what this also says, and I think it's important to note, this is a difficult program. We don't deny that. As you saw from the documents that we submitted last month, significant demands are made of the individuals who join this program if they're going to move forward. And the fact that we have had people who have left I think represents a realization that they have come to, and or that the Brotherhood itself has come to, that they're just not meant for this program. And the fact that this program is so demanding, I think, emphasizes the fact that this is indeed a strict religious use, because it does indeed emphasize that there are significant demands that are placed on these individuals, religious demands, and in many cases, ultimately these individuals are just not comfortable with them or not able to meet them. And so our view is that this supports the fact that this is truly a religious use. Having said that, I also want to make sure, is the board aware, did you receive the email and whatnot that indicated that we had reached out to the gentleman who had indicated he was the head of the neighborhood group at the last meeting, and had offered an opportunity to come and visit the premises? I assume you also then have his responsive email. I will make no comment. I'll let the board decide for itself how to read that responsive email, but we just simply believed, unfortunately, that it didn't, did not make an actual visit at this point productive. We're hoping that that can someday happen. But I just want to make sure the board had that. And now I guess I'll ask the board a question. I think you've all seen the series of emails that have been fairly recently submitted by several neighborhood residents, which, in my mind, frankly, raise issues and questions that are not legally relevant to the question of whether or not this is a religious use. I am, however, prepared to address some of those issues if the board would prefer that I do so. So I guess I turn to the board and say, do you want me to go a little bit into those matters, or would you rather I not?
Well, I won't presume to speak for the entire board, but I think it's probably important that you make whatever record you feel you should make before the board, as opposed to our determining what record you ought to make. So I'll let you make whatever record. You have the floor, Mr. Ressler, and you have the opportunity to go over or not go over whatever you choose to do.
Let me raise then just a couple of points. Again, I believe these are not relevant legally to the question of whether or not we have a religious use here. But I think it's important, because some of this stuff is out there, that we at least address this. One of the big things that came out in the emails over and over again is this fear about these people with criminal records and the danger that they pose allegedly to the community. I can tell you, and Deacon Leibold, I believe, can back this up as well. Father Wins provided me with this information, although he was not able to be here tonight. The 5 current postulants who are residing at the house have absolutely no criminal background whatsoever, none. The other 12 postulants that appear on the list that you have, and again, I'm referring to the postulants. You know, I know we had the other program that got discontinued that may have been different, but the postulants, the people that swore to the Brotherhood, of those, only one person had any criminal background whatsoever. That gentleman actually came to the Brotherhood in his 70s. The criminal matter in his record was very ancient at that point. He had actually spent 3 years prior to joining the Brotherhood as a postulant as a very devoted member of the church, which the Brotherhood belongs to, and only then decided to become a postulant. And frankly, is not with us today only because, as he reached the age of, I think, about 75, a year and a half ago, health concerns made it imperative for him to move to a senior assisted living facility. The senior assisted living facility had no concern about his prior record in admitting him to live there. So I wanted to get that question out of the way, just even though I think it's totally irrelevant to what we're talking about here. I think that's probably the only question I think I really need to address. No, I guess let me address one more. There's been several references in the emails to an organization called the Bridges of New York, which the Brotherhood does have some affiliation with. I brought a couple of pages of the webpage from the Bridges of New York, which again I will pass out. Excuse me, thank you. And it is the Bridges of New York which is not the Brotherhood of St. Joseph itself, which runs that program that was objected to previously and which was discontinued when we lost the court case. And what this website indicates is that the Bridges organization itself makes no advertisement or claim whatsoever of any location in Rochester, New York. They claim they have 2 locations, in Freeport and in Newburgh. So,
The administrative office is...
the administrative office is here in Rochester. Thank you, Keith.
Because I was going to say, Mr. Hessel, it's interesting that above the 2 locations, neither which is in Rochester, they have a picture of the Upper Falls.
The administrative office is here, but the program is not being run here. We discontinued that because of the court decision. Thank you, Deacon Keith, for catching that one on me. So to that extent, I think this confirms that we are not out there. I know there's this website, and Deacon Keith, do you want to speak to the fact that we made an attempt to get ourselves off of that website?
Yeah. Our administrative offices are run out of Trinity Communion Church over on Winona Avenue. We have a deacon there who basically does all of our accounting and documents and paperwork, and Father Wins, who previously lived in Rochester before he was assigned to a parish in New Paltz, is involved in Bridges as the executive director. And they do participate in a county task force across the strait, one of which is, I believe up here it's called SMART, if I remember the acronym correctly. And because they occasionally attend a meeting up here, Deacon DeMont will go to the meeting, see what's going on. They're listed on their web page as a resource. We asked their webmaster to remove that a number of years ago, but subsequently Deacon requested that they be kept on the mailing list, which puts them back in the database, which put him back in the website. And then after our last hearing here, he called again and asked the webmaster, please remove the references off the resource page, which he did, and a week later, it was back up. And we called again after receiving the email saying that the information was there, and again requested, I believe his name is Michael Blake, who is their webmaster, and he sent us an email apologizing, saying that he would continue to have us on the email list so we could receive correspondence from the task force, but not have us on their resource page.
Thank you. So we've tried, and hopefully that's going to get taken care of and corrected as well. Other than that, I think we have nothing else to present at this time unless the board has questions.
Well, I reviewed watched the presentation from the December meeting again, and one of the questions that I was trying to figure out as we were going through is, who is in charge? Because the impression that I'm left with from the meeting and again from watching it over is that these 5 postulants are living together in the house, and there's really nobody who's in charge. There's somebody who lives within 2 miles, but there's no supervision. There's no curriculum like you would normally have at a seminary type thing, and I understand this is not a seminary. But who is in charge?
Well, we do have spiritual formation, so I wouldn't say there isn't a curriculum. We normally don't have written or signed agreements for postulancy. That sort of came out of what we believed the town wanted after our court case. There was some dialogue between the attorneys, and they wanted something a little more formalized. Normally, you wouldn't come into postulancy unless a brother, a priest, or a deacon recommended you and said, this is somebody we might want to look at, invest in him. The house up here is looked after by Deacon DeMont, who spends time in the house, not less than 10 hours, not more than 30 hours a week, daytime, evening, with the men, and we do have issues that come up occasionally that he goes there as the spiritual director to address. There is progress that's noted. I don't want to, it's not a curriculum, it's an individual spiritual development. When the priests at the parish, the brothers that are around him, see that an individual has reached a place in their life where they perhaps might be ready to make a more formal commitment to either diaconate, the priesthood, or as a brother, they're approached about that. If we don't think they're ready to do that, then they're not approached to do that. It's not like a corporation or a program. There's no program in the house per se, because the men get up, they pray, they go to work. The individuals who didn't go to work were either retired. We did have on your list, there was a couple retired gentlemen. They were recovering from a surgery. We had a gentleman who stayed with us for over 2 years who got open heart surgery and was unable to work. The one gentleman who the attorney spoke of, Urbano, who left recently. He didn't leave last year. He left around the holidays. Liked to smoke. He's not allowed to smoke in the house, so he would go out in the garage, open the door, and sit in the garage most of the day. And he was retired and just hang out. He would, take buses to where he needed to go, and part of what he contributed to the house was keeping it clean. So that's what we do. I just saw there was an email that was circulated that, well, they sort of have these agreements and it kind of smells like a program. Yeah, we wouldn't normally have written agreements as such, other than we believed it was an accommodation to what the town requested us in order to have someone stay there. That's why we have them all for everyone.
All right, so it's Deacon Dumont who's essentially the
Yeah, but the house does not have an abbot.
No, I understand.
I don't mind telling you, the house
No,
doesn't
I
have an
understand
abbot.
that, but-
We did put a call out for one. We've had a call out for one for several years, for someone to come and live there full-time as a brother and stay there. We actually canvassed the East Coast last year amongst the communion to see if we had someone who would move up here and live there, and we do not. And we have 2 priests at the local parish, and now we have 2 deacons, and so they don't have anyone full-time. We do have evening activities there when they come home from work, and Deacon Dumont does go over there 2-3 days a week to do morning prayer, make sure the men are doing morning prayer, and see them off
I just
to work.
meant if there was a problem, he's the person who's...
He calls, he's within 10 minutes, him or one of the priests would go over. We do have occasional problems there, especially when we have young men. They may get into a disagreement and need a mediator, and they sit down and you do spiritual formation with them and say, look, this is how you work things out. We don't allow smoking in the house. We don't allow alcohol on the property. And if these young men want to take a try at this, and they're active in parish life, these are the rules to be here. And when they violate the rules, Deacon Dave is the ordained clergy who steps in right now. We also have a retired canon who frequents the house.
In advertising, you might want to mention to them that we have great mild winters.
I was actually shocked not to see snow on the ground. I have packed my car with snow boots.
And am I correct that the property itself is capable, I think Father Wynn last month mentioned, of housing up to 22 people?
Yeah, when we purchased the house from the sisters, there were 24 beds set up.
What is the Newport House, just for my own?
The Newport House?
There's something on the web that says Father Wynn was at the Newport House, and just wondering,
See that? Oh, Newburgh.
Newburgh, not Newport, Newburgh.
That's okay.
Is that something that's here, out of town?
That's in Orange County, New York. It's a 10-bed, it's a facility that has 15 beds. 10 beds are contracted with the New York State Department of Parole, and 4 beds are available for men who need shelter.
Again, that's the program we are not running here.
Yeah.
That's the program that was being run here.
Correct.
Okay.
When you look at the list of 17 men that had signed agreements there, were there other men that stayed there in the last year that had no signed agreements?
No. We have not allowed anyone who would not sign that postulancy agreement to be in that house since we lost the court case.
Well, that's not entirely true. We do have,
Sorry?
if there's clergy who come into town,
Well, I'm
or
sorry.
members of the Brotherhood, they're allowed to stop in, so we do. I'm there at least once a month, sometimes twice a month. We do have, we do have other priests. If there's somebody traveling through, every member of the Brotherhood in the Northeast knows about that location. If they're traveling to or from Canada, or, to and from different areas, they are welcome to stay there for up to 2 weeks without notifying the bishop they'll be in.
I don't think that was what you intended by your question, Mr.
Well, I
Hammond,
wasn't
but-
thinking so much of traveling priests and so forth, but others that may be at the other end of the scale. Maybe they could
That was the point I
possibly
was
be
making.
considered for postulants, or not. They were just traveling through.
Not since the court case, no.
During the day, if nobody's there, I'm sorry.
No, you go right ahead.
During the day, if no one's there, the building's locked.
Yes.
Everybody gets a key.
There's, the way the house is set up, there's combinations. There's an electronic lock system. With a combination, it's, everyone is assigned a combination, and we know who comes and goes when. So if somebody says they're working and they're not working, we know about it.
Well, I was there a couple times in the last 4 days or so, and nobody seems like they're around. I mean, the shades are all drawn, it's tight, and the doors look locked. I actually tried to open the door that you say to come in where the doorbell is. The outside door was locked, and it looks like there's no combination there. It's just,
No,
you need
there's a
key.
back door by the garage that has a combination lock on it that the men come and go from.
Oh, okay. All right. I tried to visit a couple times, actually 3 times, and never, and one of those was a Saturday, during the middle of the day, and nobody was around.
Everybody works, and around the holidays, I know a lot of people were traveling.
And also volunteering, not just working, but volunteering at
Yeah.
I did talk to a neighbor, and unfortunately that neighbor's not here tonight. I walked and knocked on a couple of doors the other day. One neighbor said that a fella had approached him for doing yard work in his home late in the year, probably October, November. And he asked him, where are you from? He told him, I live in the halfway house across the street.
Okay.
So, I mean,
I understand.
again, the gentleman, didn't let him do any work and said thanks, but no thanks. But I guess he tried to explain everything where he lived across the street. I don't know who it was, and obviously that neighbor's not here to discuss it. So, I mean, it's all hearsay at this point. But it just,
I understand.
the neighbors seem to think it's a halfway house. And I just wondered that nobody around to keep an eye on things.
Okay.
I have a question. I wasn't around back in '08. Some distinguished board members were. So I watched it all on DVD. And I pulled up the Bridges of New York transitional housing contract from '08. And I pulled up the Brothers House contract from 2012 right now. And they look pretty much the same to me. So you just said a minute ago, father, deacon, brother, I don't know which one it is, but that you didn't really want to have the second one, felt like maybe you needed to for the town, but at the end of the day, I have 2 in front of me, and they look pretty much the same, except one talks a little bit more about religious issues. But they seem to be pretty much the same document. So my question is, based on the paperwork and based on, what I'm seeing, it's just a different name for the same thing.
Well, like I said, we don't have, as a brotherhood, a document per se. And again, when we settled the court case, we were pretty straightforward. Okay, what does the town want to see and who can live here? So I didn't actually craft that document, but it's not something we normally use. We don't use it anywhere else. And it was just a record of, town wanted to know exactly who was living there, and they would agree to something. So I'm sure Deacon DeMont crafted up some type of commitment letter and sits down with the men and says, he goes over it step by step with them and says, okay, This is if you want to stay here, this is what the town requires of us, sign it. I don't,
I guess my question is, can you distinguish then between, it looks like the requirements for being a postulate that I see on this piece of paper are the requirements for someone who was staying at the house before. So what can you say to convince me otherwise, that this is entirely different?
Again, the requirement to stay in the house is that you're a baptized Christian, you're a member of the local parish, you come with a recommendation from someone who's in the brotherhood, and you commit to keeping the prayer of the hours and to work.
I think it was Father Wins, said the last time that, I believe in response to your question, that you don't have to be a member of the local parish, and in fact, you don't have to be a member of the church, your congregation, whatever your church is, that someone can come and, someone can come and live at the house.
That's absolutely correct. They have to, you can't become a member of the church in a short period of, in a week. Brotherhood does not have sway over what the local rectors do or don't do in their parish, so there's a catechism class. They have to be intentioned to join the church, but they come with a recommendation from one of the brothers. If they're not part of this parish, if they come from an Anglican church or a Catholic church or a Baptist church, and they're a baptized Christian and they understand that this is part of what the brotherhood does, they're allowed to stay in the house while they go through that process. If they decide, and some men do, that I don't want to be a member of this church, this really wasn't what I signed up for, they leave.
So, based on those individuals, how many of those individuals didn't make the list? The ones
Everybody who stayed there is on that list. To my knowledge, we asked for a definitive list of every man who has put boots in that house under that agreement who was not a priest, deacon, or brother.
Understand. Just even the short-term ones that might not have decided.
If they stayed less than 14 days, for some reason, if they came and stayed for a week and said no,
right,
and left, they might, and I'd have to ask Deacon Dave, they might not be on that list, but there isn't that many of them.
Okay.
This is funded by the coffee sales and rent from the postulate?
It's funded by the Brotherhood, by the Brotherhood blend, which is coffee that they sell, and there's a common pot in the house. There's bills every month that come in, and each man pays according to their ability.
Is there any state public funding that comes in, or do they receive? Do the individuals receive help to live there from, any state or county program?
I can't answer that definitively. I know the men that I communicate with there all work. Like tonight when I was there, the 3 gentlemen that I was sitting with came home from work, we made dinner, and I came here.
So you're saying, Father, that the 5 postulants that are living there, none of them have any records at all?
That's what Father Wins reported to me.
That's what you're stating?
Yes.
In terms of religious classes, there are no classes taught at the facility, is that correct?
There's Deacon Dave does a Bible study once a week in the evenings, and I don't want to say your life in Christ, but if you had a catechism, he goes over certain parts of the catechism at different parts of the year, has a discussion depending on where the men are in their spiritual formation who are there.
Is that voluntary for the 5 to attend?
No.
It's not, it's mandatory.
Yeah.
There are no other Sunday services or anything at the facility?
Not at the house, they go to the local parish.
They go to the local parishes?
We do have a chapel in the house, which is used for morning prayer, and if we have a priest in, they'll do Eucharist.
I was one of the distinguished board members of 08, so I've been run through this before. And what's bothering me is there was a decision made back in 08 after a lot of deliberation, explanations, and trying to define things. But the underlying problem, as I see it, was that this was an activity, an organization, or a structure, whatever, in a residential neighborhood. I really don't think anybody, either on this board or in the audience, has a problem with the whole idea of the postulants and all that, everything. But the situation is that it's located in a residential neighborhood. So we ruled that couldn't happen. Went to court. The court agreed. Now, I didn't know until it was just mentioned that the town of Arundecoit specified rules about which people could live there. I've never seen that list and never heard of it until tonight. Nevertheless, in our discussion, even though this is not the same program, because I was there last time in '08, the idea of the devoutness, the prayer times, the fellowship amongst people, the influence of the church, it really, honest to goodness, it sounds like kind of the same thing to me, with a few changes in nomenclature. For example, postulants was never mentioned back in '08. Now that seems to be the most common word of this whole presentation. And I'm having a problem voting for something that I can't be absolutely sure fits in a residential neighborhood, especially over the objections of the neighborhood. I really need more convincing.
Well, and all I can say to you is your town code, for better or worse, allows religious uses in the R1 district. And I think we've made a presentation that is very adequate to show that this is a religious use.
Well, that's my question. I don't think it's an adequate portrayal of a church or a religious use. We're assuming, but we as a board haven't seen any religious activities, nor have I've been there 3 times to try to get in to see anything that is, the way I grew up, what a religion is all about. So we find, other than having men living in a home, which looks to be like a group home, or a halfway house, there's no proof other than a plaque on the wall that says it's the Brotherhood of St. Joseph's. And, the fact that he's wearing a collar and the other gentleman was wearing a cross. I mean, it's nice to say, but the neighbors don't notice it, and we've visited and we haven't noticed it. So you've showed us some paperwork, but it's tough.
I wish you'd given me a call before you went over.
Well,
we could have probably arranged a time.
I went 3 different times. I mean, obviously, you're right. Maybe I should have, but if I don't know, I don't see it, and I guess that's the problem with most of us. We don't see the true religious background that you're trying to say is there. It looks like just a place for the guys to live that may be having some tough times and trying to rebound.
I do have one question, well, several questions.
Go ahead.
The first one was, I think Father Wins last month said that some people had stayed there for a 3-week period of time. I was waiting to see if someone else brought it up, just out of curiosity. I mean, he made it, I'm almost positive he said around a 3-week period of time. So I heard that there might be people who stayed at this piece of property for less than 6 months, and that they didn't end up on this list. So my question at this point is, how many are there, and why weren't we told about them? I mean, it's possible that there were some that were there for under 2 weeks, that they never grew their roots yet, but do you know what that number is, and why didn't you disclose it to the board when we asked for that information? The next question that I have is, I'm looking at the 5 letters from the postulates, and when I read over these letters, 2 of the letters talk about becoming members of the Brotherhood. 3 of the letters talk about staying at a house. When Father Wins was here last time, he explained that the reason that you become a postulate is so that you can enter the Brotherhood and be a part of the Brotherhood. When I look at these letters, I am reading letters from people who are staying at a house, not people who are on a spiritual mission to join a brotherhood. So I'm wondering if you could speak to both of those. I mean, when I read these, and it seems like people are talking about staying at a house, and when I hear that there are people who are staying there for possibly 2 weeks, possibly 3 weeks, and leaving, and there's no record of them, I question whether or not the people who are going there really want to be members of the brotherhood.
Sure. Well, it's a little difficult for me only because I'm not here day to day. I'm going to make an assumption that, like our other houses that the Brotherhood does have and our other places of vocation, if people come in and want to visit and stay for a few days, they're not formally put through a process. How many are there? When I've been up there, I have not seen someone stay in the house who has left in 2 weeks, but I'm not going to say it hasn't happened. I can't stand here and tell you that it hasn't happened. Regarding the letters you received, the men are in different places of spiritual formation. There are 3 men in the house right now that I would definitely say are on a journey to something more than just looking at who we are. There's some gentlemen in the house that are just, they think they're ready. They come to morning prayer, they read their Bibles, they serve on the weekends, they go to the soup kitchen, but they are not at a place right now in their spiritual formation where they really understand the sacrificial life that we're asking for. But that doesn't mean we're not willing to let someone try who comes to us, meets with Deacon Dave, sees parish life, and says, yes, I want to do this.
If I can just quickly add, though, when you look at those letters that don't mention specifically belonging to the Brotherhood, you still read that there's a deep spiritual commitment to what they're doing there. I don't know how you can describe that other than it's religious.
If I were to compare to the normal religious structure, church, chapel, convent, rectory, priests living in the convent, nuns living in,
Yeah.
or the vice versa. That's what's there. Do they let outsiders or anybody just, the church I grew up with, the rectory had 3 or 4 priests in there. Was anybody allowed to stay there? I don't think so. Occasionally, did they have a relative or a friend stay and visit? I would think so, but it wasn't a revolving door of men. This is more like a
We
hotel.
say a revolving door, though, but most of the men in that list are staying for, at least a year.
Well, and again,
And then we're having a discussion with them and saying, okay,
to
you've been here for 12 months, let's talk about really where this is going.
and again, if it's not a religious background and they're just staying there because it's a nice warm spot to stay till they get themselves on the ground, they could tell you guys anything you want. They could tell you, hey, I'm trying to be spiritual, and I'm trying to raise up above it all. And I believe they probably are. But are they really doing it because ultimately it's brick and mortar and a warm bed and some food?
We
They're
work through that with them, yes.
right. And I know you're going to save some of them, and they're going to go on to better things. But and others will make it on their own also. But that sounds more like a halfway house.
Well, the primary difference between what Bridges of New York does as a program is that through state funding, the religious part of a program does not exist there. So comparing these documents to one another, I think it is not a fair comparison. And again, normally we don't even do this. That's why Father Wins was a little befuddled. Why he said, "Well, where's a case manager?" It's like there's no case to manage. These are men who are willing to take a shot at it, and this is one of the ways that we, as a communion in our diocese, discern men who are looking to serve Christ in ministry full time. I did speak with the bishop today about this. And he asked me the same question he asked me when the court case settled. He said, look, try and get an understanding from the board on a property that the Brotherhood owns, who can live there? Like, who can live there? That's what he's asking. I mean, we didn't buy this house looking for trouble. We didn't want to come into a neighborhood and...
But am I to understand it's an R1 residential, so it's a...
Yeah.
So it should be one family living.
Well, actually, I'm looking at the
ultimately-
town code, section 235-8, that defines the permitted uses in RR, R1, R2, and R3 residential districts, and single-family dwellings is first, but second is churches or similar places of worship, parish houses, convents, rectories, or parsonages. And if I understand what you're describing, it's a group of men who've all made a commitment that really only they can tell us what the sincere depth of that is, but they've all signed on to and agreed to live a life that will lead to more responsibilities in the Brotherhood of St. Joseph's. Ultimately, I think after 25 years being the ultimate state that someone would reach in the hierarchy that the Brotherhood has established. Is that fair to say?
Yeah, you commit your life to the order.
Right. And while they're living at the property on Winton Road, they're free to come and go as they please. There's no one there who tells them you have to be in by a certain time tonight, or I need to know where you're going. I understand there's no, you don't do drug testing of these individuals. You don't have organized, formal program of whatever type that's there. There's a deacon who stops by between 10 and 30 hours a week, who's their spiritual guide, who is checking in with them, that while they're there, they are pretty much self-responsible for their spiritual development and growth, assisting each other, and meditating and worshiping, studying the Bible, going about in their individual and collective ways, developing their spirituality, hoping at some point that they're going to be able to move on in the Brotherhood. Is that essentially what you're describing?
Yes, except the house does have some structure as far as when you're back in the evening, unless your work calls you. We do evening vespers.
Okay.
And we do morning prayer at 6:20.
We have a list of the past postulants, but do you know how many of these people have gone further and made it, or they?
I know at least 3 on that list that I recognized.
And giving the sacrifice that's required of particularly reading through the original submissions and what's required and the lifelong commitment that you're contemplating, I can understand that the quote-unquote success rate might not be the same as...
One of the reasons why, just so you know, one of the reasons why this property was purchased was because the corporate charter of the Brotherhood almost word for word mirrored our Sisters of Charity, I think was the name of the order that owned it before us. So even though zoning aside, that's what they looked at when they went to purchase the property.
And I guess the concern I have, which I'll direct to our attorney, is that I think that we get in a difficult position if we try and impose whatever our personal understandings may be of a particular religious use upon the religious use that you've defined. Now, my understanding is you're incorporated under the not-for-profit corporation law for religious purposes. Is that correct?
Yeah, we're an integrated auxiliary of the cathedral, is the IRS term.
And I think once we've established that you are a religious organization, then the question becomes, I don't think we have, quite frankly, a whole lot of room for exploring the particulars of how you choose to do it, as long as we're satisfied that it's being used as a parish house, convent, rectory, or parsonage type use, as opposed to the halfway house use that we found it was being used for 3 years ago. Would you agree with that, Mr. Ressler?
I would agree with that.
All right.
Mr. Chairman.
And hopefully Mr. Borelli can expound a little more upon what this, the zoning ordinance.
Well, I think both sides have very accurately marshaled what the issue is ultimately going to be. And that really is going to be whether or not they fall under Section 235B, pure and simple. But I do say that the decision that was written on April 10th of '08 still has full force and effect. It was a different set of facts. The halfway house concept probably is not applicable to the presentation today, but I think you have to read that decision, and it has to be taken in context of all of the proof that's been presented in the application today, and it's a decision that the board is going to have to make. And again, I caution you again, as I always do, if I give some guidance with regard to the direction you may or may not go, please don't take that as any indication whatsoever that I favor one side or the other. I'm only trying to take, the best legal position and present it to you. And in this instance, I still maintain, I think as I did, Mr. Ressler, when we began, that we can't take this application out of the context of the order. That's the order of the court. That's the best and most recent legal guidance that we have, although admittedly different. And there is you can distinguish it because of the halfway house concept. The court pointed out that the Brotherhood sought to use the property as what the court considered a residential ministry, where the brothers could live together, as well as taking in some men who were what they characterized as broken or spiritually deprived. I leave that to the board to decide if that's still the case. That was the characterization that Judge Taddeo made. When this board, or its predecessor board, denied the application and again, April, on or about April of '08, or at least when the decision was written, clearly the board determined that the house was not a single-family residence. I don't think that's in dispute right here.
It's not the issue that we raised
I understand
on this
that.
appeal. That's correct.
Again, the prior non-conforming use, there's been a lot of reference made to the acquisition of this property from the sisters, but it doesn't seem to me, and again, I leave that up to the board to decide, but this does not appear to be a continuation of the prior non-conforming use.
Excuse me, Dan, just a question. Isn't this more of a situation that the court should answer instead of us?
No, you've got this.
We get the first choice, and then
You go first.
whoever's unhappy with our decision gets to ask the court to.
But all I'm trying to say,
what he's
Carmen,
saying,
is
yeah.
that in that '08 decision,
The court made the decision.
Judge Taddeo touched on many of the objects. And Mr. Ressler, I invite you certainly to respond to what I'm trying to point out, because obviously one of the points that was brought up then was that the property was being used as a halfway house, and it is clearly the position in this instance that it's not being used that way today. Whether any proof has been presented to indicate that is up to the decision of the board, and the argument of the applicants certainly should be taken into consideration. The incorporation is something, I don't know that your incorporation has changed. Maybe you should elucidate on that more, because in the decision it was stated that the Brotherhood is incorporated under the not-for-profit law, not the religious corporation law. So there is a distinction between those two, and maybe you might want to clarify that somewhat, because I know the chairman thought that was an important situation. The court pointed out unlike true family units, the clients are considered transitional residents who can be immediately discharged for violation of the house rules. Again, do the facts fit that particular observation that was made by the court? I think that needs to be determined in this case. And then ultimately the religious issue. And I don't think that you're asking on a strictly on a First Amendment basis here. If I'm wrong, I apologize. But the court went on, I think, to point out that there's nothing in the use of that buildings in distinguishing this transitory residence concept that would prevent the building from utilizing the chapel and utilizing the chapel for religious ceremonies, even if you excluded the living component of it. So, I mean, there's some guidance from the court, but I know in certain terms I advise this board that it is distinguishable. There's no question, but there is guidance. And I think in the end, my advice to you as your counsel is that you have to do exactly what your chairman properly did. You've got to look at Town Code Section 235B. And Mr. Essler, I'm happy to say that I'm quoting from your submission now, so there isn't favoritism in any context here.
So I'm really in trouble now.
Well, sometimes we know that, but I mean, as this facility falls under the classification, you've heard the proof. I think the decision needs to be made under the classification of churches or similar places of worship, parish houses, convents, rectories, or parsonages. If you marshal then the proof that's been presented in this particular case with regard to whether or not this particular use falls into it, use your own notes. I mean, I took notes as the presentations were made. Clearly, there was many instances that the applicants indicated that there was formal commitments to the brotherhoods that was required. These so-called postulants, and I mean no disrespect by saying so-called, that there's a religious component to their residency there. But likewise, the concept of supervision, the concept of the regularity of the life that they leave there, that I think is something that's relevant to whether or not it applies to 235B and how those might be applicable.
And I guess I'll make one response and then ask Deacon Keith to expound a little bit on the incorporation issue. But take a convent, for example. I sincerely suspect that almost any convent you would go visit, the nuns do not stay there 24/7. They have jobs. They teach. They're out there in the community. They're not living there all day long. And in fact, I'd be willing to bet you, even though we're not arguing for this proposition here, that they do have people that they take in for short-term periods of time as part of what they believe to be their religious function. We're not doing that now in terms of at least what as Father Wins has explained it to me. We've tried to get rid of that short-term Bridges program that you're seeing elsewhere in the state for the disadvantaged person that just needs a place to stay for some period of time. No, we're looking for more. I think the documentation shows, and with all due respect, that there is more in the documents that reflects a sincere requirement of a religious commitment than was in the previous documents. So that's my answer to that question, and then I'll let Deacon Keith address again the corporate issue, although I don't think that the mere fact that it's not a quote-unquote religious, formed under the religious corporation law is legally determinative, but I'll let Deacon Keith again explain exactly how that fits in.
My recollection of our consideration 3 years ago was that the argument was being made that it was a church, and therefore it fell under church and single-family residence. Those were the two arguments. I'm not hearing an argument that this property is being used as a church. I'm understanding the argument to be that it's being used as a rectory, as that term is.
Rectory/convent house, yes.
Right.
Would be by definition a convent.
Yes.
Under the, I'm not an attorney, I'll leave that area of expertise to you gentlemen, but we were told that when religious orders form, they form under a particular corporate law in the state of New York, and it's what we're formed over, it's what the corporation is formed around, it's what the sisters that own the property prior to us were formed under, and that the federal government considers it, and the phrase is, an integrated auxiliary of the cathedral. I don't claim to know exactly what that means, only that that's what it's formed under. I do know 3 years ago, part of our perspective was that part of the building was a church because Mass was said when there was a priest at morning prayer or evening prayer. So to that extent, how you define worship space, we would consider that church.
But we acknowledge that it's not a regular Sunday.
It's not a regular Sunday
Public-
meeting. If a
public
priest is at
services.
morning prayer, or sometimes at Vespers, if the canon shows up, they celebrate Eucharist. They have an altar there.
I have a question, Mr. Chairman. This is a situation, if we were to approve this application tonight, if you want to call it, it's an application, what assurances do we have that this doesn't segue back to what it was in '08? I mean, yes, we have a different non-program, I guess you would call it, that would, we would have to just kind of take it in faith that this is going to be used as a convent/rectory, which I still have a little problem with that. My main question is, what precipitated the fire marshal's order of eviction a few months ago? What precipitated
And
it?
again, there was an incident where a gentleman was actually asked to leave the premises because he was not willing to abide by the rules that he had signed up to abide by. And several days later, he returned in an angry mood, claiming that articles of personal property of his had been stolen, and he then dialed 911 and called the police. The fire marshal, I guess, the code enforcement officer was not available, and the fire marshal came. And out of all the whoop-de-doo that ensued, the fire marshal felt, we have this court case, and this, I can't, as I stand here, it looks to me as though this may still be the same thing. I'll be honest with you. I've talked with him, and that's what he told me. And therefore, he wrote it up.
Yeah, Mr. Thomas, I think I can confirm that recitation of what occurred. And there was an incident. Officials from the town were called to the residence. The observations that were made by the town authorities were that it appeared to be a use that was similar to that use which was precluded by the '08 decision. That letter was not written immediately. There was consultation, which included myself. Based upon the information we had at the time, it was concluded that that letter would be sent. Also, it should be stated, I think I said it at the outset, that the decision to hear your application in context of the prior decision was also reached by the same parties to give you an opportunity to present the fact that it may or may not have been something different, or alternatively, that it is an applicable part of Section 235B.
Correct.
You're still left with the decision, regardless of what happened in April of '08 in the decision, which, again, I emphasize that the board should take into consideration, distinguishing it, but nonetheless take into consideration. A lot of facts have been presented that are independent of that period of time, that were brought about because of the complaint, and you now are faced with the decision of whether or not they're in compliance or not.
I think my point of bringing that whole thing up actually was that the complaint came within
Correct.
the place and not from a neighbor.
Correct.
And I think that's kind of an important point.
I guess that's how you look at it. It depends on how you look at it. I view it as an important point in that this is not a use that's really out there disturbing the neighborhood. There just happened to be an individual who had an angry reaction over having been dismissed from the house.
Once you brought that up, I kind of remember that now as being said before, so I apologize for bringing it up
No, no,
again.
no.
But
Yeah.
I wanted to be sure that I understood correctly and that everybody listening to this understands that correctly, too.
There had been, and it's part of your record, a number of police calls to that property over the last 2 years. And I think that's another reason why maybe, I mean, they were never be able to get in to figure out what was happening. And when they were called by the people themselves, it was a chance to get in. So it's not like neighbors never called about the property. They did, and you have that. It's a 2-page list of phone calls.
Gotcha. Thank you.
Any other questions of the applicant?
I have a question coming back to our attorney on section 235B. Jim, where it alludes to the various types of usage that would fall under a church or similar facilities. And I guess I wonder, since they're not incorporated under the religious corporation law, but rather as a non-for-profit, that if they don't fall out of that category altogether.
I would have to reserve giving you a decision on that. I'm not sure that absolutely precludes them. I'd be inclined to suggest that even though the incorporation isn't absolutely under the religious corporation law, that if it's a true church, then it would still be entitled to that consideration.
But if it was a true church, they'd likely be incorporated under the religious side of the law and not the non-for-profit, would they not?
You would expect that, but again, a church notwithstanding, a church is a church. If it looks like a duck,
True.
it sounds like a duck, it's a duck. I don't mean to be, but and likewise, if that's exactly what they're doing here, then I think you're entitled to consider it that way.
I have a question on that last point. I think the sense is if it were a convent or a rectory completely, that, that falls within a religious use. When you were before the board in 07 and 08, there was at least one member of the Brotherhood staying at the house at that time. Is that right?
That's correct.
Now there are no members of the Brotherhood who are living there apart from the postulates on a regular basis. Is that correct?
That's correct.
Okay. So I guess my concern is this. If I want to say this is a rectory, this is where the brothers live, but there are no brothers here. There are only people in training. And there's no one who lives there with them who's actually a member of the order. It's just people who are training there living on their own with someone 2 miles away. It's in that gray area between where we were 4 years ago and it being something that we know was a religious use. Could you give me any thoughts, give all of us any thoughts or any comments on why...
I wish we had an abbot who would come and live full-time at the house, and we don't. And as postulants, we consider them part of our order, and we do have a deacon who comes usually for morning prayer. Like I said, he's there most evenings with the men. We have 2 men in the house who are almost at the place where we're going to be recommending them for more. But yeah, we don't have I stay there, like I said, I'm there a couple times a month. There's other priests and deacons who come in and out of the house. I've never had, the first time I had someone come to the house when I was there was one of the board members stopped in for a visit. That's the first time anybody's knocked on the door when I've been there.
Have you gone out and met the neighbors?
I have not, no.
Has the father that was here last meeting gone out and met
Father
the neighbors?
Andrew is not. We've just,
Wouldn't that seem like a good idea, since the neighbors are upset with it?
we,
As I think in your materials, we did try to reach out this time.
Well, you did for
And the-
one guy by email, that's
Well,
correct.
but the response we got, again, I'll let you interpret the response.
I know.
It was one that I was not willing to recommend to my client, that it would be a productive use of time to have that person, to have us be required to do what that person was insisting we do before he would come to the house.
Well, I guess, thinking about it, the time to go out and meet the neighbors might have been several years ago when you first took over, rather than waiting until we've got a fury here in the neighborhood of people that are upset with you. Now you're afraid of getting run off.
Yeah.
I'm just curious.
Any other questions or comments from the board? All right. We'll now turn to the public portion of the hearing. Is there anyone here who wishes to speak in favor of this application? Is there anyone here who wishes to speak in opposition to this application?
Richard Barone, 154 Allwood Drive. I'd like to raise a couple issues. There's a big difference between a rectory and a parsonage. People are not coming and going. Yes, they go daily to work. They go teach, perhaps the nuns do. But they're not moving from parts of the county, parts of the city in and out, like this is moving. You got transient people, for lack of a better word. I know that doesn't sound very good, and I don't mean it in that intent. But you have people coming and going, not just coming and going because they're going to work, but they're coming, staying for a while, and then leaving. That's not the same as a rectory. It's not the same as a convent. Also, a church has a regular thing. Now, you can say a mass any place. You can say a mass, for example, at wartime on the field. You can say a mass in someone's house. That does not make it a church, because you can say a religious service in someone's house or in a particular hall. So those arguments made by the applicant, I believe, are not valid. Now, I take no position on this, but this doesn't sound like it would fit the requirements of the town code. I think the town code seems to speak about something that's permanent, that's ongoing, that's regular, and is periodic. Not something that could change and not be there 1 month or 1 week and then all of a sudden be there. So the consistency of a church or a synagogue or the Kingdom Halls, for example, I think the activity is an ongoing activity. You have someone there all the time who's a religious person, a priest, a rabbi, whatever. You don't have that here. So the board member Paulino indicated this might be a gray area. I think it's more of a grayer area towards what was turned down by the courts. Yes, there's some grayness here, but, you gentlemen will have to draw that line. Thank you.
Hi, I'm Dee Dee Tahirovic. I live on the corner of Helmore and Tarrington. I spoke at the last meeting. We all know where this is at right now. I just am very concerned because there seems to be more questions than answers to, I think, a lot of our questions. I felt there was a lot of contradicting within their speeches. I found that it says they pointed out that there is no drinking and smoking on the property, yet it is okay for this one elderly man who's there to go ahead and smoke on the property in the garage. I just found that quite interesting. Also, concerning about the 17 people who you received as a list, it would have been nice if the neighboring people, if the neighbors would have gotten that list. It would be nice to have been disclosed that information. And I would like to know, are these 17 people, are they included from when this was first called a halfway house? Or is this after it was no longer called a halfway house?
Well, just so the record is clear, all right, and I probably should have done this earlier. The list that's been provided to us includes 17 names, 5 of people who are there currently, and 12 of people who resided there previously. None of them have a start date that predates our prior decision of January 2008.
Okay.
The ones who are there now have been there the longest is since May 1st of 2009. There's a new person from September 1st, 2011, October 1st, 2011, October 1st, 2010, and May 3rd of 2011. Those are the 5 that are there now.
Okay.
The 12 preceding that were there from August 15th, 2008 to September 30th, 2010, from January 2nd, 2009 to January 31st, 2010, from January 23rd, 2009 to June 30th, 2009. I believe that's the shortest stay of the previous people. July 1st, 2009 to February 1st, 2011. February 15th, 2010 to February 28th, 2011. March 15th, 2010 to March 31st, 2011. April 1st, 2010 to July 31st, 2011. May 1st, 2010 to December 7th, 2011. September 16, 2010 to December 13th, 2011. September 16th, 2010 to May 31st, 2011. October 21st, 2010 to August 30th, 2011. And I was mistaken, this is the shortest. November 25th, 2010 to March 14th, 2011. So those are the 17 people in terms of their length of residency at the property.
Okay.
And that is something that, and Donna, correct me if I'm wrong, but I believe all the material that's submitted to us is available, right?
Oh, okay. Also, what I would like to bring to attention with the names, as I recall of last time we were here, Father Wines, I believe, when stated that there were 9 postulates there. So I was just wondering, so they have already ended, basically, because you have written letters from 4 of them, or 5 of them, but you don't have them from 4.
Well, it was interesting because our meeting was on December 5th, and 2 days later, one person left.
Okay.
And 8 days later, another person left. So I hope that wasn't anything that we did at our meeting that caused them to leave, but...
No, that's fine. Also, it has been said that it's going to be used as a religious use, but yet I find it quite peculiar that they are involved with an organization, Joe's Coffee Bean. And if they're involved with a for-profit business organization, if they're supposed to be 100% set on religious workshops. Like, I understand that it's supposed to be them moving on to the next level, yet they are working outside of this. And I feel like, well, if you're trying to get to the next level within the priesthood, or however that the levels and the process of getting to each point, wouldn't these people be more set on being there, attending workshops that might be given 100%, like constantly working on getting to that next level? I just feel that they shouldn't be really having outside jobs if they're really serious about doing this. And I understand that they have bills to pay, but if you're considering yourself a religious organization, wouldn't any of the church funds or somebody be supporting that? Maybe I'm stating the question wrong, or, but it's just, I just kind of think that's a little fishy on my side. So, yeah, that's it.
I did have a question for you. In the materials that we received, and I'm not sure if they came from you or Mr. Di Maria, but in the package of materials we had was a listing of tax-exempt organizations with their financial information. And I'm wondering, as I read through that, I was trying to figure out what the connection was between their financial circumstances and the issue that's in front of us.
I didn't send any. I'm not sure if my mother has sent anything to you regarding that.
Okay.
So I'm really not sure about that. And that's it. Thank you.
Thank you.
Anyone else wish to speak in opposition to the application?
Good evening. Joe DiMaria, 525 Tarrington Road. First off, I'd like to address Mr. Essler's invitation to tour the facility. I received an email, I believe it was 4 or 5 days before this meeting, to tour this facility. No one else received the email. We've got many concerned neighbors, but I'm the only one that gets this. Now, I realize that I'm the head of the neighborhood watch, but we've got concerned neighbors. Why not an open house? Why are we waiting 4 days or 5 days before this meeting before DiMaria gets invited to this facility, but nobody else? It was very suspect. I didn't trust the invitation, and I wasn't comfortable with it. That's why I did not go. I'm sorry. I just wouldn't take the invitation up. Secondly, after the invitation, you received a barrage of emails. All the neighbors, it was going back and forth. It did go through a lot of neighbors. You could not see them because I BCC'd them to protect their identity. Probably Friday afternoon, somebody from that facility, and I'm not going to mention who, rode by my house very slowly, staring at me, giving me dirty looks. I've got the plate number. I'm going to work with the police. I'm not going to mention the individual's name because I believe we're on television here, but we'll take that from there. Several points I'd like to make here. I know Mr. Leibold is not familiar with this facility. He knows parts of it. He doesn't know all of it, and therefore he was a little sketchy in his explanation tonight. If you Google his name on the internet, you'll see why he does not know much about this facility. He is connected to real estate deals all across the state, millions of dollars worth of real estate deals. He is the president of a construction company down in New Paltz or Newburgh, and they're constantly building $4 or $5 million projects. I've got copies of them here if you want to look at them. That really does not mean anything for this facility, but what it means is that's why there's no supervision. That's why Wins is down in Poughkeepsie and he's down in Newburgh. They've got other things to do. There's nobody here watching this facility. These gentlemen are coming and going and there's nobody there watching them. That is a big concern. Secondly, there was, of course, the connection to the bridges of New York. They've explained that tonight. On the web, I don't know if that's what they mentioned. I didn't catch it. On the web, it's still showing that the Joe Bean Coffee Company is connected to them and to the bridges of New York. Is that what they mentioned, that they tried to get the website corrected? Or was it the bridges of New York?
My understanding was that it was relating to the concern that we raised at the last meeting about the fact that they were still listed as a housing resource for men.
Okay, well, let you read this that's printed off the internet as of this afternoon before I got here. I only have 2 of them. I'm sorry I didn't bring enough if you want to pass them around. This was printed off the Joe Bean website as of today. If you read this, they're pushing it right in front of our face here. It says, currently we run houses in the counties of Nassau, Orange, and Monroe. Okay? In 2009, we partnered with Joe Bean to sell coffee to directly benefit the residents of the Bridges program. Now, artisan roasters at Joe Bean developed a blend of coffee to be sold exclusively for the purpose of helping addicts and ex-cons get back on their feet. What is that? That doesn't sound like a postulant to me. Now, they're saying Monroe County, and then it goes on. It says the end product is not only a concern for the Brotherhood of St. Joseph or for Joe Bean Coffee, but for those who grow the coffee for us. Joe Bean Roasters buys 100% fair trade, blah, 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 and it goes on and on. It does make mention of the Bridges of New York and the Brotherhood of St. Joseph. It's connecting them to this facility, and it's connecting them as of 5 hours ago or 4 hours ago, whenever I printed it. I don't think anything's changed at this facility, quite frankly, and I think that once you let them in there, if you do let them in there, it's going to go right back to the way it was before. Couple other points. Regardless of what you call this facility, I believe that they're still accepting people that are down on their luck, that have drug and alcohol problems. They may not be convicts, but they have problems. Those people wandering our streets should not be in a residential district. It just does not fit the bill. There's plenty of properties around this city, downtown, everywhere you go, to run these type of facilities. I have been finding numerous little nip bottles of vodka or bourbon all over the streets, and they're leading up towards their facility. I was going to bring them in here tonight, but I didn't think it was appropriate to carry in all these empty bottles that are being thrown on our front lawns. They're there. You want to come to the neighborhood tomorrow? I'll show you where they are. They're all thrown right on the lawns, all the way up and down Winton Road. I don't know. I can't accuse them of it, but they're there. I haven't seen them before. I've seen them in the last 2 years. And I keep throwing them in the recycle bins, and they keep showing up again. I believe they've allegedly changed the focus of this program, but I don't think they're going to change the participants of this program. And I don't think it should be allowed in our neighborhood. We've saved all our lives to buy these houses. We've saved all of our lives to have a house, enjoy it, to try to put some money into it, to fix it up, to make the neighborhood nice. I don't want to be living around convicted felons or whoever they are. I just don't want them there. And I have no problem with religious orders, but I don't believe that's what's going on here. I think we're getting smoke blown on us. If you want to see those other, I don't know if it makes any difference to you, but you can have these too. You can see all the money that passes through their hands. I'm sure they'll be part of the public record. In closing, I just don't think we can have this facility in this neighborhood. We've got families, we've got children, we've got a daycare. There's no supervision. There's comings and goings. Anything I've heard, nothing was concrete. I have been by this facility probably about 10 times in the last few weeks, and it's locked up tighter than a drum. You don't see anybody. And I'm going to tell you, I truly believe that is until this goes through. And then you'll start seeing them outside again. They are in hiding until this is all done with. It's locked up. The curtains are shut tight. There's nobody around. Those garage doors are closed. I don't see anybody walking the streets. Nothing. That's what I've observed, and I'm always looking. That's all I have to say. Thank you, gentlemen and ladies.
Is there anyone else who wishes to speak in opposition to this application? You have to come up to the podium, state your name and address, please.
My name is Nafia Zanilovic. I reside at 430 Tanton Way in Webster. My sister lives at 683 Tarrington Road, Drita Taharovic, and she asked me to ask if she could appear by phone, if that would be... No?
No, we don't have the...
No, they're really, I appreciate that might be helpful.
Right.
There's actually a very specific section of the
Okay.
law that does not allow that, because this is a public meeting.
Okay. I would like to add that I frequent my sister's house a lot, and I have seen personally the men sitting in the garage all summer long, drinking beer and smoking, unsupervised. I witnessed it. So for them to sit here and say nobody sits out there and drinks is wrong, because they're never around to supervise these men. So, thank you.
Is there anyone else who wishes to speak in opposition to this application? Deacon Leibold and Mr. Essler, do you wish to respond? One question that did come up that I do have that I would be interested in having you address, just to see if my understanding is correct, was the relationship between the Brotherhood and the Joe Bean Coffee. Can you just elaborate upon that?
I'll let Deacon Keith start, but I can then just repeat what I remember Father Wynn saying last time. But essentially, it's a fundraising method for the Brotherhood, and it is used indeed to further the activities of the Brotherhood. And the fact that these individuals apparently, as I understood it from Father Wynn's, who reside at the house, participate to some extent in the coffee program. It's a means of helping other people.
I don't know how Father Wins met with the Joe Bean Group. It was at some public event, and there was some discussion about coming up with a custom brew, and they spent about 8 months coming up with a blend, and Joe Bean took it and runs with it. Just so the board is clear, I do own a construction company downstate. I'm bivocational as a deacon. Most deacons are.
Can you talk into the mic or
Sure.
switch spots? Sorry.
So the board is clear, I do have a construction company downstate. Part of my bivocational diaconate, I build affordable housing, senior housing. We do some work for Oasis, doing facilities, building projects downstate. I'm also on several nonprofit boards, as well as serving on the boards of the Brotherhood, on the Board of Bridges, and I am sort of the diocese administrative business deacon.
Thank you.
We have nothing else to add.
Okay. All right, then this hearing will be closed, and we will take a recess till 5 after 9. As I look out, it appears that the applicant is still here for 340 Rock Beach Road. Of course, we have the applicant here for Winton Road, and the applicant with respect to the sign at the Ridge Goodman Plaza is not here, so we will do that one last, and we will start with the application with respect to 340 Rock Beach Road. This is a type 2 action for seeker purposes. Does anyone wish to make a motion with respect to this application?
I'll make a motion that we grant the variance as applied for, even though it is very close to the lot line of the neighbor, and it will have a little effect with the overhang as we were discussing. I believe it will not be any feasible alternative to them to do this, and with them, it actually would hide the boat a little better after visiting the site. I believe the requested variance, although it is substantial, the variance would not have an adverse impact on the physical and environmental conditions of the neighborhood, and the alleged difficulty is self-created, but will not, as I mentioned, have any adverse effects on the neighborhood.
I'd like to ask a question. Are we allowed by law to permit one neighbor to put his or her property on someone else's property?
Well, that's not what we're
Are we allowed to grant a variance that encroaches on someone else's property? Mr. Orelli?
I don't think that you're granting the variance to encroach. You're granting the variance to have those pylons come up against, and I think one of the things it's not necessarily my place, but the applicant, I think, should be cautioned that if the neighbor takes offense to any encroachment, that would be an issue between those two parties.
What if we made it she did say, she signed a letter saying that it was okay to put it right on the lot line, but what if he got, as part of the stipulation, a new letter saying that she understands that it's going to hang over 8 inches, the top part's going to hang over 8 inches, so she is not surprised after the fact?
If approval of the application is, if that's something that you would
Subject to.
require for approval, that's within your purview.
I would think that we should
Yeah, I wouldn't object to that.
add that as a stipulation. I know she knows, and I know he did mention that she would be all right with it, but I think she should see it and understand it just in case. So that would be a stipulation.
Is there a second to
I'll
that motion?
second. I'll
Okay.
second.
All right.
Yep. That sound good? She signed on.
Yeah. So the owner of the adjoining property to the east is to indicate approval of any potential overhang onto her property. Is that correct?
Yeah.
Is there any other discussion? All those in favor say aye. Aye. Any opposed? Any abstentions? There is no one absent. The motion carries 7 in favor, no opposed, no abstentions, and no one is absent. Next item is the application with respect to 1280 North Winton Road. This is a type 2 action for seeker purposes. I have prepared, just to help us in our discussions, I prepared 2 alternative motions with proposed findings. They're not meant to be exclusive. It was just as a guide to help us in our discussion of this matter. I would move that and this is, I think first, perhaps Mr. Rell, you can clarify this if I'm correct, but it's my understanding this is not a variance application. This is, we are being asked to determine whether or not the use of the property at 1280 North Winton Road is in conformity with or not in conformity with the town zoning code. So I would offer a motion in order to foster discussion that we find that the use as presented is consistent with Section 235, is it B or 8?
I thought it was B.
Either B or 8 of the town code. My eyes aren't what they used to be. As a...
Actually, it's 235, 8 parentheses B, so it's both.
8B. Okay. With the following findings, that the Brother of St. Joseph is a duly constituted religious organization incorporated for religious purposes under the New York State Not-for-Profit Corporation Law and owns the property located at 1280 North Winton Road, which is within the town of Arundecoit. The property is currently occupied by approximately 5 individuals who have signed an agreement of postulancy obligating them to serve as postulants in the order in accordance with established rules and practices of the Brotherhood and subject to approval by the Council of Brothers, but the property has the capacity to house as many as 22 individuals. The postulants reside together, sharing among themselves the expenses associated with therewith as part of their commitment to lead a life devoted to their religious principles and there are no specific services of any kind afforded to them during their residency there, although they are expected to be employed, provide service to the local parish also located in the town, and to provide service in the community through established organizations, many of which are independent of the Brotherhood. The property is located within an R1 residential district, which generally forbids multiple resident arrangements. However, use as a church and related uses such as a rectory or convent are permitted in the district. The use of the property in the manner represented by the applicant in its written submissions and testimony offered under oath at the hearing is a use that is related to the ministry of the Brotherhood and is therefore similar in nature to a rectory or sister's house, which is permitted within the district. And I would also propose that a condition of the determination be that on a quarterly basis, the Brotherhood provide to the town a listing in the manner that has been provided of the number of individuals who are residing there, how long they have been residing there, and certify that they have all signed agreements of postulancy that have been presented to us. Is there a second?
And if we say, and we disagree on your motion?
Then it fails. And then there'd be an alternative motion which follows on the next page.
I'll wait for the second one.
Does anyone wish to second the motion? All right, so that motion fails to receive a second. So then I'll offer a motion that we find that the use of the property is not in conformity with Section 235-8B of the Town Code. In addition to the previously stated finding concerning the Brotherhood owning the property was the subject of a previous application before this board for use as a halfway house offering rehabilitation services to individuals as part of its mission, which application was denied by a duly adopted resolution of this board on January 7, 2008, which denial was subsequently upheld by the State Supreme Court in a decision rendered in an action commenced against the town and having index number 1890-2008. Criminal proceedings against the Brotherhood in the Irondequoit Town Court were resolved with a written stipulation entered into between the town and the Brotherhood, which permitted certain members of the Brotherhood to remain in residence at the property under certain terms and conditions. The fire marshal issued a notice to vacate dated October 19, 2011, based upon his determination that the property continues to be occupied in violation of the applicable provisions of the Town Code pertaining to R1 residential districts. It appears that the property continues to be listed and referred to in various publications and information sources as a residence for men, and the applicant has failed to provide sufficient information to establish that those entering into agreements of postulancy are doing so for religious reasons as opposed to a means of securing a residence under circumstances which are not consistent with nor permitted in an R1 residential district as defined in the Town Code, and the use of the property does not constitute a church or any related use as defined in and contemplated by the provisions of the Town Code pertaining to R1 residential districts. Is there a second for that motion?
I'll second that.
Yes. Discussion.
You said it all in your motion.
Yeah, I think that does sum it up pretty well, to tell you the truth.
Now, I was, as we were doing, even though I made the motion, as we were going through this, I went back and read through Judge Taddio's decision. And one of the things that she makes reference to is that in the circumstances that were presented 3 years ago, that the clients were considered transitional residents who can be immediately discharged for a violation of the house rules. It seems to me that what we've been presented with is information that I don't think casts these individuals as transitional residents or transient residents. It seems to me that what exists is far closer in my mind to what falls within the characterization of a rectory or a convent than what would be a halfway house, which was what we were presented with 3 years ago. And my feeling is that falling within that means that it is permitted, whether it meets our individual standards as to what we would expect it to be, as long as it's legitimate. So that's, and I don't see proof of the illegitimacy, but I don't see it the same way that others do, apparently.
Well, while I agree that it does seem that there are some differences from what I heard and what I read from the 2007 and 2008 hearings, I'm having a hard time getting past this Brothers House Rule of the Postulate document, which does say, one of the things that, Mr. Chairman, you said earlier was that, no drinking, they couldn't be drug tested on command or whatever it was. Well, under the Rule of the Postulate, they can be drug tested at any time. They have to be in the house by 11 o'clock, and there are a whole laundry list of other requirements that mirror those found in the 2008 housing contract. And the Brothers Postulate Rule contract also says that if you fail to abide by them, you can be thrown out immediately. So, to your point, it does seem that they are not members of a family or members of a religious order who are in it for life. They're in it to give it a try, see if they like it, and they can get kicked out. And they might even be there for such a short period of time, we're not even going to make a record of them. So it does seem to me that it has maintained its, transient qualities. The residents, there's still room for them, for people to come and go under the radar, in and out, and it doesn't seem that it has that stability that a religious order would have.
Mr. Rowley talked about the idea of if it walks like a duck and acts like a duck, it must be a duck.
Well,
I'm
let
not
me
saying it's a
let
duck,
me
but-
rephrase that characterization. Again, I think each of you make a point. This is more likely than not as close a call as you've had been brought before you. The consideration that the board is going to have to undertake is whether the use of this house as a resident for these individuals who have been described throughout the proof constitutes a permitted place of worship, a parish house, a convent, a rectory, or a parsonage. That is the decision that you're called upon. And again, when you marshal, when you gather up all the evidence that you've considered, you can call upon your own individual experiences, you can call upon the observations that you have made personally regarding this particular use and this particular piece of property. You can call upon the information that has been brought forth by the applicants. In the last appearance, there was a number of other individuals who came forth and made representations. Members of the community came in and made representations regarding what they've observed. Again, I'm just going to charge you that you should take all of that information together. Then you have to make the single decision, again, whether or not the use of this house as a residence for these individuals constitutes a permitted place of worship, parish house, convent, rectory, or parsonage in an R1 district, of course. So that's the decision you're called upon to make. Not whether it's a halfway house, not whether or not they continue that alleged use of the residence from 2008, but whether it constitutes the parish house, convent, rectory, or parsonage. That's it.
I stand by my initial belief that it's not really a religious place.
Is this a two-part motion? You made one motion one way, and now you're contradicting it, or what? How does?
No, there are two there are two decisions that we could make. One decision is that it comports with the town code. One decision is that it does not.
Yeah,
So
but
I prepared motions for both.
Right, the second one you just made, and then you commented on it, is almost contradicting what you're saying, so.
Right, I offered the motion just so that, because I'd taken time to put together some very specific findings, which I thought would be helpful in the event that the decision, whatever it was, were going to be challenged. So I put together what I thought would likely support one decision and what would support the other decision. And since I'd put it together, I put it out and read it. But personally, my opinion is that it is in conformity with the provisions of 235-8B as a rectory or convent. I think what separates it from what was being done previously is that there is not somebody living there. It's not closely supervised. Any program that I'm familiar with is a tightly regulated 24/7 operation with very restrictive rules on coming and going, and these rules do not, in my opinion, come anywhere near that. They more closely approximate what is likely to be, in my view, taking place at convents or rectories where the residents are going about in the community doing work, getting together to further their religious purposes in, as the deacon said, for morning prayer and evening worship. And quite frankly, it seems to me that in this case, what the testimony is supports the view that under their religious views, these people are there making a commitment to serving, dedicating their life to service of the brotherhood. Now, whether they ultimately go on and do that, the statistical information which we'd requested, which Mr. Essler provided concerning the number of days that people have been there. I mean, most of these people are there for over a year, some of them for as long as close to 3 years. So
Those are just the ones that are written down.
Well, they are
They're the one. Admittedly, there are some that are not logged in and haven't made that list.
Under 14 days, that's absolutely right.
But isn't this,
Unfortunately,
this is your opinion, it's the motion, are you making any actual motion?
the motion that I made, which has been seconded, is to find that the application does not.
Right, that's the first.
Right. That was the second motion that I made. The first motion I made was that the use is in conformity with the town code. That died for lack of a second.
Right.
So the next motion is the alternative, because the fact we have to make, as a board, we have to make a decision, one way or the other, which means it has to come up to a vote.
And somebody second this? That you?
Yes. This motion was seconded. The other motion was not.
So it's
So the
seconded.
motion that's in front of the board now is to find, for the reasons that I stated and any other reasons that anyone wants to add, that this use is not in conformity with the town code.
Right.
Right.
But then you added, after that, the fact that your opinion.
Right, I'm discussing it.
Right, okay, that's.
Right.
That's
I'm going to vote against it, but I'm offered the motion
Okay,
in order to frame the discussion and to get a second, because the first motion
Right.
obviously didn't get a second, which means we couldn't discuss it.
All right.
And we have to make the fact that we deny an application does not, in other words, we make a motion to approve an application and it fails to get a second or is denied, is not the same as making an affirmative determination denying the motion. So that's what's now in front of us, is the affirmative motion to find that this is not a use that's in conformity with the code for R1.
Right.
I was just trying to frame it in both ways, not knowing what the sentiments of the others on the board might be after the hearings.
Can I ask a question? Can we consider, as we're considering all the facts that were presented to us, how to weigh them based on certain other facts. For instance, the documents say that there's no drinking or smoking at the property, but I believe a member of this board, when he was at the property, saw people drinking there. So
You can absolutely put whatever weight you want to whatever piece of evidence that has been presented to you.
So we can say that if it is the case that a member, if I'm not mistaken, Mr. Santora, that if a member of our board, when he was there, saw someone drinking that, there, and it's been represented to us that that is not going on, that we can then credit or discredit other testimony accordingly?
Yes.
Yeah. We each make our own determinations about what we believe and the weight we give to whatever we hear.
So on my part of this discussion too, and I'm going to vote in favor of this motion because of two reasons. One of which is hearing testimony about the alleged lack of supervision at this place, which to me, I have quite an opposing view from Jim, but to me that does not sound like a rectory. Not that a rectory is a quasi-prison or anything like that, or a monastery, but there is no supervision there. Any help is a while away if there's any problems, and there have been in the past. And the second, and probably more important aspect of this whole thing is the people who come from the neighborhood to show their concerns about this situation. Now, they may not be legalese type of people, but they're neighbors, and they've been around and around on this, and they've been here at our meetings, and they, as far as I'm concerned, that's our number one responsibility, that these people who live there can do so without the concerns and the fears of what may or may not be going on in that other facility. And because of the lack of supervision, we can't guarantee anything. I don't think it's our role anyway, but nevertheless, we're trying to interpret this code. Why is the code written the way it is? And I think the underlying thing in all these provisions for the code has to do with the health and well-being and happiness of the residents in an R1 district. That's why I'm going to vote for this motion.
Any other discussion?
I have just a question. If this motion were passed and it was found that the appeal is denied, the applicant, or the appellant rather, could make an application to the board for a use variance?
That's an interesting question. That was the last paragraph of Judge Taddeo's decision. That application had not been made at the time, and it hasn't been made up until this time, so
If they had called the town in the first place before they bought it and said what they wanted to do, we would have probably said, go for a use variance for the first program they were doing. That was clear.
Because, it does seem to me that this property is a unique...
But let me caution you, what an eventuality may be, or what a potential move might be, shouldn't drive your decision. You should make your decision based solely upon the proof that's been presented in the hearings.
Because it is a unique piece of property, but all things being equal, it seems that the use currently is more like that from 2008, in my opinion, than not.
The motion that is in front of us finds that it is not a use that's permitted under the zoning.
Yes,
So-
it finds that it is a use that's similar to that in 2008, which also wasn't allowed.
No, it finds that it's not a permitted use.
Yes,
That's
correct.
the only finding that we're making, is that it's not a permitted use under R1.
Correct.
So it's not a parish, parsonage, or rectory or convent. Right? So in order to continue and stay, then, yeah, I think a use variance, as Judge Taddeo suggested, would be an alternative. Another alternative is to seek a opinion from a higher authority, such as a judge of the Supreme Court, which is also open to the applicant. Any other discussion? All those in favor say aye.
Aye.
All those opposed, a nay. Any abstentions? Motion carries, 6 votes in favor, 1 opposed, and no abstentions, and all the board members are present, and no one is absent. Next item is the matter of 1381 and 1455 East Ridge Road. This is a type 2 action for seeker purposes. Does anyone wish to make an application or a motion with respect to this application?
I'll make a motion. In reference to 1381 East Ridge Road and 1455 East Ridge Road, and the 2 signs to be redone. I make a motion that we approve them based on the information and the size of the presentation. I don't believe that there's I don't think it'll hurt the character of the neighborhood. As a matter of fact, it's going to help the character of the neighborhood. It is a nice, new, pretty sign. Alternative solutions are to leave the old sign in decay or take down the signs, and I don't think that's a good alternative. I don't believe it's a substantial variance because it's approximately the same size with the addition of the clock tower. It will not hurt the environment. It is a self-created problem because the old signs are old and they want to update them. So based on the criteria, I believe we should approve them as applied for.
I'll second the motion.
Can I make a suggestion there? We had someone made the suggestion here at the podium that we incorporate in addition to the passing of this, that says they are limited to the 2 signs, and if they want to add additional signage, they have to come to the town and ask approval. I think that's probably a good idea.
Personally, my own personal beliefs is no. Being in the retail business for many, many years, I believe that some of the little extras that every now and then that have done out in front of a store to help promote business is not a deterrent. So I don't want to add that to my motion unless there's a discussion, for anybody else. But
No, that's your motion.
All right. Any other discussion?
I think it was Joe. Did Joe or?
They drew it on there, but it hadn't been determined yet what it was going to be.
Again, it's not something I need. If they want to landscape around it. Pardon? The town would like it?
I will second the motion with the added provision that they provide ample landscaping according to the drawings they submitted.
Yep.
So what are we putting, appropriate landscaping as reflected on the drawings?
Yes.
Yes,
Good.
I think that's
Yep.
fair.
All right, all those in favor say aye.
Aye.
Any opposed? Any abstentions? Motion carries, 7 votes in favor, no opposed, no abstentions. All members of the board are present, no one is absent. I believe that concludes our business for this evening, so we will be adjourned to February.
Do we have to approve, or did we already approve these?
Motion to adjourn, second.
Nice square.
We approved those
I
last
think the town board approved that.
Did they? All right, okay.
I wish you would keep
Mr.
it.
Hinman, did you move to adjourn?
All right.
Pardon?
Yes.